A very warm good evening to all present here. Today we are with us Dr. Jitendra Kumar and Dr. Paresh Dave on the third session of the International Strategy for IPR Conventional Strategies Web Series third session. Now I hand over the session to Dr. Paresh Dave. Might be some technical issues from Dr. Paresh Dave. Let me introduce with Jitendra Kumar today or speaker for the session. So I request to Jitendra Kumar with the continue with the today's session. We having the web series. This is the first week third session of the web series, and it is powered by Open Pharmacy Federation and IP Moment, both in collaboration with the Sri Ram Krishna Institute of Computer Science and Education. Before that, this is the online certificate course on patent searching. As we discussed yesterday and the day after, day before yesterday, the coordinators for the event, Dr. Paresi Dave, founder and director, IP Moment, and Dr. Ratna Trivedi, head of department, environmental science, Sri Ram Krishna Institute of Computer Education and Applied Sciences. This is the NEC recognized organization situated at Surat, Gujarat, and it is affiliated to Veer Narpal South Gujarat University, Gujarat. And one of the our coordinator is Dr. Jay Bargi, head of Department of Biotechnology, Sri Ram Krishna Institute of Computer Education and Applied Sciences. And on 27th of July, we have discussed with Harshita Vasant. She is talk on the intellectual property rights activities. And yesterday we have discussed with Dr. Paresh Dave on the intellectual property rights and conventions. And today we having Jitendra Kumar Sharma. So we will be discuss more about in this web series. This is the third session of the web series. And next week we are planning more webinar series. So we having speakers with us, Alistair Cruston from New Zealand and Nobendu Bhattacharya from Bangladesh. So we having also planning the international speakers for this webinar series. So we request you all to join next week also there. What is the main concerns of the or webinar series? That is the international intellectual property rights treaties and conventions, how the treaties are going on there, what is the Bern conventions we had discussed with Harshita Vasant, and what are the TRIPS agreement, patent corporation treaties we discussed with Dr. Paresh Dave, and today we discussed with Jitendra Kumar Sharma, Madrid protocol, and all the things going with the Madrid protocol, and hug agreement, and UPOV, plant protection, and Budapest treaty. So all the treaties we will be discussing in the upcoming webinar series in next week. We having renowned speakers with us, and all discussed with us. All previous sessions are available on same YouTube channel. So we request to all the audience, you can go through that YouTube channel, and you can join the take the advantage of these sessions. Now I request to Jitendra Kumar Sharma to continue with the today's session.
Good evening, everybody. I hope I am audible to you all. So thank you, Dr. Paresh and Dr. Vikram Chaudhary for giving me this opportunity. So today I will walk through the Madrid Protocol, which is called as International File Links for Trademarks. So this is the protocol which help us to file our trademark brand in across the globe, and this is something which helped countries to come together and can identify the rights of individuals in from their base country to the other part of the world. So as we have already discussed about the patent cooperation treaty and other treaties like for Berne Convention for copyrights, so this is specifically for brands and trademarks. So I will walk through the slides. I think Vikram, can you put up my slide on it? Hello, Vikram. Vikram, your voice is breaking. Can you put up my slide on it? Yeah. So thank you, Vikram. I will request you to move to the other slide. Can you move to the other slide? So yes. So as intellectual properties is concerned, like they are categorized mainly in four buckets. One is called the inventions, which are done for patents and a new idea, innovation idea. The others are design symbols, the literary and artistic work, which are for copyrights and all, and name and images used in commerce are for trademarks. So these are like four buckets or four verticals where we can categorize intellectual property rights. And as we have already discussed about patents, copyright, trademarks, geographical indication. So these are like four intellectual property rights which individual get on different IPs. For example, patent we get for innovations, copyright for any literary and artistic work. Trademark is like any brand name, and geographical indications are like particular product which has a particular region specific uh, growth, like for example we have tea from Assam and all. So these all things come under geographical indication. In India we do have design registration of designs, but across the globe they are identified into different category, and that is the reason I have not specifically classified it in this slide. So for example, in United States they are called design patents, but we call it designs. So that is for our IPs. Now we can move to the next slide. Vikram, can you just scroll down to the next slide? So Madrid is a system. So if I talk about like when this Madrid protocol came into the picture, so previously there was Madrid agreement, who was which was very successful. However, the agreement has some limitations. To overcome the gap and to mitigate those gaps, uh, they come up with Madrid protocol, which was like more effective, which helps individuals, corporates, companies, organization to be centrally file their trademarks and brand names, which is like more beneficial rather than agreement. And as on today, most of the countries which were part of Madrid agreement are now part of Madrid protocol. So where it is located, where the trademarks are, like their local office, where is the international offices are there. So Madrid is governed through World Intellectual Property Office, which is in Switzerland, Geneva. This is the treaties. Similarly, as the Patent Cooperation Treaty is governed by WIPO, similarly the Madrid Protocol is governed by WIPO. So this is something like that. they are keep adding members to these Madrid Protocol. Like the countries are becoming part. Recently, we heard about Canada, which was not a part of Madrid Protocol, but now they will be participating in the same filing system, which will help like people to export to Canada as well, to get their brand registered centrally rather filing the trademark application specifically to that jurisdiction, which is like a lot of cost and a lot of extra work which is required. So can you move to the next slide? Vikram, Vikram, can you move to the next slide? So as I told in my earlier conversation that in the original treaty there were about 55 members of this Madrid Protocol. However, as soon the time passes and a lot of countries have started recognizing and the advantages, the benefits of Madrid Protocol. So India is like the is having the more benefit out of it. So we are also part of it. And if I talk about the data that till June 2019, there were more than 106 members for this. So which is like great participation from across the globe, which includes if you can talk about any country. So now Madrid includes each and every country. So they are still growing, and with each passing years, they will be coming up to more than 122 members. Like they will definitely get all the countries under Madrid Protocol. There are different if I talk only about trademarks, there are different protocols and different filing system. Like the Europe provide the community trademark, which is called the CTM trademark. So CTM is also very good like a platform as a Madrid protocol. However, there is a very small or and an important aspect which gives benefit to Madrid protocol compared to CTM trademarks, because when we file community trademark, if your trademark application is rejected, sorry, if your trademark is if your trademark is rejected in your community trademark, it will definitely get rejected in all the members of the country. However, in Madrid, if your trademark is rejected in any particular country, you still have the application uh, registered in other part of the world, like in other countries. So this is like a benefit which Madrid have over uh, the other CTM trademarks or the other filing systems. So can I have the third slide? Can I have the other slide? So before we talk about the previous slide, Vikram, the above the previous slide. Can I have the previous slide? Slide number 6. Yeah. So before we get into the filing system of Madrid Protocol, I would like to go through what understanding what are trademarks, what are brand names, and what we domain names, why they come into trademarks and all. So as the slide says that, and most of the people know what are trademarks. So these are just like a symbol, uh, mark or a name or a number, which could be a coined and an invented term which can identify the goods or services from one to another. So it's like a basic meaning or a definition under the Trademark Acts of what is trademark. So this is called the trademarks. So I've shared an example like Dell. Dell is a trademark that identify the goods like computers and the other related objects. Citibank is a trademark that relate to services like banking and financial services. Similarly, there could be other companies like Apple for computers, laptops, iPads, and Nokia for mobile phones. And so these trademarks are identified between goods and services. So if you want to actually understand how these are classification are done, these are like the every product is classified into a particular category, which is which is governed under the Madrid Protocol and the NICE classification. So there are about 1 to 45 classes where these products and services are categorized. They are put into a bucket. So if I talk about the goods, so they are considered under class 1 to class 34, and the services comes under class 35 to class 45. So that's all about the trademark, what is exactly as per the definition under the Trademark Act. Now we come to the second slide about what exactly is what I would say, uh, what for layman, what is trademark, like how he recognized that it is a trademark. So trademark can be a word, which I have taken an example as a Snoopy. Trademark can be a combination of combination of colors, different images. So, like the Coca-Cola has a trademark for combination of words. Coca is a different word, cola is a different word. So they combine together. So this is like a very important aspect of the trademark, that even when generic terms are combined together to be used, they qualify as a registered trademark. They can be registered. For example, we take an example of like a company came up with something that they would be doing some automation thing. So there have been trademarks in the history, like complete automation, which is a trademark. If we talk about the term, the complete word is term is a generic term. The automation is a generic term. But when these generic terms are collaborated together, they qualify for a valid trademark. So there have been trademark like Coca-Cola, like complete automation. There have been numerous trademarks which are combination of different terms, and they qualify as a trademark. The second comes like the abbreviation. So a lot of people try to register their abbreviations as their trademark. I have taken example as BMW. The full form is different. They have the trademark on BMW, but they have a trademark on the whole terms as well. So similarly, like my organization, MetLife is not a MetLife is a name. MetLife is like a Metropolitan Life Insurance. So MetLife is our abbreviation, you can say that. But we have a trademark on Metropolitan Life Insurance. We have a trademark on MetLife. We have a trademark on Met. So similarly, BMW has a trademark on their abbreviation. So now the fourth one comes the numeric. So I've taken an example of number 7, which is number 7 in the numeric form, and 11, it is in alphabetically, that they have written 11. So this whole qualifies for a trademark. So this is a very good big store across the globe. So that's the reason to differentiate how we can recognize trademarks, how what qualify for a trademark. So these are the categories which qualify for a trademark. There could be numerous examples which can come together that they qualify a trademark. And so these four are the best suitable example which I could have explained what are trademarks. Now exactly comes, as we are discussing on Madrid Protocol. So filing through Madrid Protocol is itself uh, beneficial for the person who is deciding to launch their products in India and other part of the world. So if I talk about the Madrid Protocol, they have their specific requirements, that when you can file a Madrid application, what are the eligibility criteria when you are going to file an international application. So before filing any Madrid application, the first required criteria is that you have a basic application in the your home country. When I say that it is a home country, this means that the country where you are filing first application, that country should be a part of Madrid application. So you should be either domiciled, either represented by an attorney, or you have businesses in that country. Then only you can use Madrid Protocol. In India, they have a specific requirement that either you have a domiciled or you have to be represented through an attorney. then only you file an Indian application. And once you file an Indian application, then you are eligible to go file through Madrid protocol. And once you file Madrid protocol, you have the right to choose different part of the worlds, those countries who are part of Madrid protocol, who are participating in Madrid protocol. So that's this slide talk about that how what are the basic things and how we move to the Madrid application. Can we move to next slide? So this slide especially talks about what to do to file Madrid application and how I will be taking care of my Madrid application. For example, I'm an attorney in India. Sitting in India, how be able to file Madrid application, how I'll be looking and searching trademarks, brands for the prior registrations, prior file application. So this slide gives a uh, very clear view that before filing a Madrid application, how you will be approaching to World Intellectual Property Forum. So WIPO provides a very good platform. You can go and they have a search facility available where you will find the global trademarks file, like the all the international trademark file under the Madrid protocol. You can go and have a search over there. So it is like a term-based search that you put in your trademark with some boolean searches and all. You will get to know like a prior trademark search report they will give you. So that is my first option, says that before filing any trademark, we do search in when we are filing in our base country as well. When we are moving towards the international filing, so firstly we will be going to filing the trademark in Madrid, which is in WIPO. So we have to do a trademark search, a preliminary trademark search in Madrid services. So they have an option where you can actually go and search the brand names, which the proposed names which you are going to file, and you can actually take a decision how you should go to file a trademark or what countries you can avoid to have a rejection for your trademarks. So this Madrid provides like a whole process where you can file your search your trademark, then you can file your trademark. You can monitor every country when the trademark application is objected, any communication come. When you are going through a Madrid protocol, you can easily get each notification through WIPO on their portal, and they will be also sending you through their email process and all. What the communication process they follow the email communication. Even if you miss your email, you can go on the Madrid protocol and you can check on a real time basis. So that is like a monitor process or monitor platform which WIPO provides for Madrid application. The third and the fourth last one comes up the how you will be managing your international application. These applications are once you start filing Madrid application, there will be, and you are entering into different part of the world, there will be a lot of renewals, lot of requirements of specific countries which you have to comply with. Like US has their own requirements, China has their own requirements, Canada has their own requirements. Some countries have you have to prove them that you are actually using the trademark. So after a period, and you after a period of 10 years, which is like almost all country registered trademarks for 10 years, there could be some examples, exceptions where some countries has different time frame. But if I talk about most of the countries, they register a trademark for 10 years. Similarly, when you are doing a trademark for 10 years, you have to file or you have to prove the use that you are actually using the trademark in that particular country. So when you are doing it through a Madrid protocol, it becomes more centric. When I talk about centric is you don't have to go in every country to file those things. You file it in your base country, you file it in WIPO, it is filed across the globe. So this is like a renewal can be done, can be managed, can be any miss can be avoided before you file a because this is something which is done centrally. So if you go and pay the fees of Madrid, your application will be renewed in every country wherever you want to renew it. So it's like a one shop solution for you, that you can go and file your trademark, you can renew a trademark, and you are not going in each and every country separately. So this is like a fantastic platform which gives you, when you are going to file a trademark in different countries across the globe. So these are some exams, some platforms like which I talk about the CTM as well. So similarly, this is a platform which is actually helping the attorneys, the corporates, and the individuals to enter into the businesses to import, export, and they can have their trademarks in a click of fingers. So can I move to the next slide, please? So here I talk about the advantages of Madrid Protocol, as I discussed earlier in my earlier slide as well, that Madrid Protocol is actually helping people on a lot of fronts. How it is helping is like the centralization process, expenses, cost, and other. So if we talk about the from my first point of view is like languages. So they consider three languages, like you when you are going to file an application, you have to file an application in three defined languages, which is English, Spanish, and French. So they recognize only in these three languages. Best part is that English is the most spoken and used language across the globe. So like mostly all countries recognize English as a language and they speak or write English, which help a lot for Madrid Protocol to go and file application in English. Like a lot of Asian countries, they recognize English. European countries, they recognize English, and the US and United Kingdom, recognize English. So this is like an advantage that the languages are globally acceptable and like more in use. So this help people to file their application through Matrix. The second point is talk about the simple application process, which I already discussed. The simple application process means the procedures are so simple, like you file your application in India, you file in Madrid, you select the countries you want to file your trademarks, and then you pay the fees and your trademarks is filed in number of countries where you have participated or where you want to file the trademark. So from a single portal you can file the application in across the globe, considering that those countries should be the member of the Madrid Protocol. When I talk about centralization, which I already discussed, centralization is like more towards the trademark filing and trademark renewals, managing your trademark, because once you have a single portal to take care of your all your trademark application in across the globe. So let's say an example, you have filed a trademark in 50 countries which are part of Madrid Protocol and you are using Madrid Protocol. So in that case, when the time will come for renewal, it will be for 50 countries, you will have the renewal time nearly about the same time. So once you renew the trademark application in your base country and you made renewed in your international application, it is renewed across the globe when you pay the fees. For an example, if you have not used Madrid Protocol and you have entered through different countries directly, for example, you filed an application in India, you filed in US, Canada, UK, Europe, and XYZ countries. So when the renewal will come, first of all, there will be a clash in the due dates. You have to monitor, manage all the due dates. Then you have to go and hire an attorney in every location, and then you have to renew and pay, and you have to deal with every individual separately to renew the same application, which you could have done it through Madrid Protocol very easily. So this is like a centralization which helps you to manage, monitor your applications very well as compared to single-handed applications. Now, the fourth point comes reduction of expenses. This is like any business would have a budget for any filings and all. So this is the first thing every business does, that when they are entering into a new business, they are filing new trademarks. They specifically do a budget exercises. So what does Madrid give them benefits? For example, you decided to file an application in 10 countries, and then you took up cost analysis for filing application. You get into touch with the local attorneys for their particular locations. You got the cost estimation, and you got X amount you have to spend when you file application through different countries. Now when you choose Madrid protocol, the first benefit which you will be getting is that you don't have to hire any attorney in those countries apart from your base country. You don't have to hire an attorney. You don't have to pay the attorney high charges for filing the trademark application. So you are filing through your base country from your base attorney. So there will be only some nominal handling charges and some charges of their official charges, which are always lesser as compared to the attorney charges. So for example, I am going to file an application in United States, in Canada, in Europe, in United Kingdom. So in China, I only have to pay the official fees of those countries plus the Madrid fees, and my application is filed. So there could be an example like your trademark is does not attract any objection from any jurisdiction. It can be granted as well without even getting an attorney involved of their location. However, if there is any objection raised, in that case, you have to get an attorney involved from that location. However, the cost comparison is very high because initially you are not paying anything about it. You are not paying any attorney of that particular location for filing your trademark. You are not paying it for searching because your attorney is searching. You may pay for a search, you may require a search, but obviously you are not paying for the filing fees. So this is like a huge reduction of expenses which you actually do. So the cost saving and speed cost is already covered in expenses. Like it is actually a cost saving when you're not paying. Otherwise, if Madrid was not there, you could have paying every attorney at a very high prices, and even the attorney charges are higher as compared to the official fees of the. So this is something which you are really making out of profit on your budget sides on your filings and well. So now let's talk about the speed. So when you talk about the speed of the application, for example, you file an application in India, then you decide to file an application in US, then China, then in other part. So you have to involve with every local attorney. You have to do the search, the filing procedures, the documentation in every country. This will actually delay your filing, which may give rise to a prior site filed application. For example, the business you filed in India, in China, on and someone like the people are always keep monitoring the brands, and they file the similar application in US. This become, it can be a coincidence as well, it can be a target as well. So your application will be delayed. You may have a prior filed application, you may get right in India, but may not get right in US because of the delay in possession. Otherwise, if you file through Madrid protocol, you will be using the priority date. Once you file the Madrid application, you will be considered that days as your trademark filing date in a number of countries. So that's something you get your filing more cost effective, more economic, and the speed also your filing and the renewal will increase. So that is all talk about the advantages of Madrid protocol. Now, because this is something really good and helping people on different filing strategies, they can easily decide when they are deciding that they have to enter across the globe, they can actually do this exercise in deciding their filing strategies, either they want to go to individual countries or they want to use mid protocol. So these advantages would help individuals, corporate organization to analyze that they should go for individual countries or they should use Madrid protocol. Thank you. Vikram, can I have next slide, please? So as everything which comes with some advantages, it also comes with some demerits, disadvantages. So this process protocol also have some demerits, but I would not say that disadvantages are so there could be some disadvantages for some people. However, there are a lot of advantages of this protocol which I have already discussed, but those advantages sometimes become problem for other people. For example, if I talk about the language limitations, which is like the fifth point in my slide. So language, which is like an English, Spanish, and French is like the most commonly used languages. However, there are countries who does not qualify for these languages, who does not recognize these languages. So those countries when participate in Madrid Protocol, they found it really challenging. So this is some benefits for others become some challenges for some other people. So that is the thing which I have used it as a disadvantages, but that's how we have to settle down with something or the other. The second or the first which I have on my slide is basic registration or basic application is required. For example, I am staying in India, I want to do business in other part of the world. Without getting my trademark registered in India, filing in India, I cannot take it to the Madrid protocol. No matter I'm using a trademark in India or not as on today, no matter my business strategy has to file a trademark in India or not, but I have to file a trademark in India then only. So this is a requirement and it has a duration as well, that in how much time you will land up with your Madrid protocol first filing the Indian application. So your mid application is highly dependable on your basic registration, on your basic application. Secondly, identity of right holder applicant and identity of marks. For example, a lot of businesses do that. Like for example, in India, they want to come in with a different color codes or with different tweaking their trademark, but in US they want to have a different design. If you talk about McDonald's, so in US McDonald's have a different color combination, in India they have different color combination. This is the right example that if in India, if they are using a Madrid protocol, they cannot do this. If they are filing an application in India in a different color combination, they have to keep their application across the globe same, total identical. They cannot have a color deviations anywhere. They cannot have that they can have a blue and a green color in India and a sky blue and a light green color. They can't even do those deviations. So this is something a challenge with businesses face because some countries have a different color. Color is used mostly like a blue color is used for legacy somewhere, green color is used for livelihood. So the definitions change when you get into some other countries. Maybe India has a different definition for a blue color, or US have a different definition for a blue color. So but if your trademark is filed in your basic application, you can't change. Not even small deviations are allowed. So your global trademark has to be identical to your base application. So this means like there is a lot of dependency of your global trademarks on your basic application, which I talk about the even if I talk about the goods and services which you offer, you can't change the services which you are doing it in India. You can't restrict those or change in US. You have to describe the services or the goods exactly identical as you have it in your base application. Sometimes businesses come up with, for example, in India they want to launch XYZ under the same trademark, and in similar category they want to extend their goods or services in US. But the application, if it is gone through the Madrid protocol, it has to have the same description for goods and services. They cannot add something which is not allowed, something which they have not added in their base application. So these comes under some disadvantages, or you can say highly critical analysis where we do for trademarks filing through Madrid, or the strategy we should keep in mind before choosing Madrid protocol. So these advantages and disadvantages mostly help the organization in deciding their filing strategies, how they have to move it. They have to file individual filings, individual countries, or they use Madrid protocol. So can I move to the next slide, please? So this I have already covered in my previous slide about the members of this mid protocol. So what is my view, and as I am experiencing how other countries are participating. So Madrid protocol is getting more famous as compared to other filing procedures, like I discussed about the community trademark. The most best example could be like, for example, you are deciding through Madrid protocol, you have a freedom of choosing countries. And for example, if let's say you file in US, Canada, China, or Australia, and your application is rejected in US, but you still have chances to get it registered in Australia or in China. But when it comes to CTM trademarks, once your application is rejected in the main European Union, it is rejected in across the members. So this is like helping countries more towards Madrid protocol, and a lot of countries are coming up to become a participate, to become a member of Madrid protocol. This will definitely increase this members, like I'm talking about India mostly. India is taking a lot of benefits out of this Madrid protocol. So mm, this is something which is like will keep on increasing. Like we have 106 till date, but they would definitely gonna increase. Can I have the other slide, please? So this is like the more we talk about basic countries. So this is actually how we will file. The slide will cover how you will be filing a trademark application through Madrid protocol. So I can we can take an example of any application filed in India. So once you file an application in India, no matter the application is granted till date, but even if the application is filed, so you have a duration in that period before the application is rejected or objected or whatever the application goes on. But you have a time frame that you can go and file your Madrid application once you have filed your trademark application in India. Then how do you file it? Exactly what are the procedures required? So theoretical, yes, you can get into the Madrid protocol. Yes, India is a participant. Yes, you can pay the fees, but how you will be doing it? So this is something which is actually help the attorneys, actually help the individual organization. So our Indian patent trademark office, they have a very good, very systematic system how you can go and file trademark application. First, you file a trademark application in India. They have an option to file an international application. There are such few formalities like an online forms you fill up. Once you fill those forms, they will charge you rupees 5,000 approx, for which is a filing fee or a Madrid handling fee which they charge the Indian Patent Office. It may increase from time to time, but as far I know that it's somewhere around 5,000 and some surcharges for a Indian officer's charge for their handling fee. So for example, you pay around 9,000 official fee for a corporate, or a 4,500 official fee for an individual or an MSME or a startup. Then after paying 5,000 extra fee as a handling charges to Indian patent application to file your application in World Intellectual Property Forum. So you have an online platform. You don't have to go and submit the documents through post or something like that. It is an online inbuilt system in already Indian patent site. Once you file the 892, it's like an application which is called Madrid application. Once you file that, your documents are automatically fetched. Your goods and descriptions, the applicant name, category, they all are fetched from the Indian application and then they move to WIPO. Now what happens is the WIPO process your application. If they find any formality requirements, they will definitely get back to you. If everything is good, everything is in place, they will ask you an email or a post which come to you, and they will be asking you the exact fees in they accept in Swiss francs. So you have different options of paying those fees. Like you can pay through any bank. You have your banks, like every corporates or individuals have their bank account. So they do provide the different modes of payment. You can go and pay through bankers. You can go to your bank and they provide you Swift code, and very seamlessly when you go to your bank, they will help you, they will assist you, and there are particular categories where the fees are paid. The bank will give you some notifications it has, and then you pay the fees. Once you pay the fees, your application is moved to different countries. So this is like sitting in one country, you file your application across the globe and paying very nominal fee. You are not paying any attorney fee or different country. You are only paying 5,000 rupees as an Indian patent office handling Madrid application, and the WIPO fees and the official fees of different countries. So you do have a calculator before filing the application in Madrid. You have a calculator provided by WIPO where you can actually calculate the charges. That if you will be entering in n number of countries, how much would be the charges. So this would actually help you to do the cost estimate of your filing. And once you file this application, your application as equal as it is filed in different countries individually. Now you can go and check their database. You will have everything like in USPTO, like in Canada. You can go to their official websites and check your application there as well. You can check in WIPO Madrid. They have a trademark portfolio links. You can go and manage your application there. Whenever there is an official letter issued from any part of the world, any country, it will be issued to WIPO. It will be issued to you through WIPO, or you can actually go and monitor on the sites, on their official sites and WIPO. So your base application, your country of originate is actually helping you to file your Madrid application. So the similar process, like every country provide the similar process. Like I talk about the India, the United States, they do have the same process. More uh, user friendly processes are people these countries are coming with more user friendly processes so that we can pay the fees online as well. So this is how the country of origin is important for filing a Madrid application. Can we have the next slide? Vikram, can we have the next slide? So this is something like the key numbers which I have which I have quoted from different search engines. These are like for data analysis, how this is increasing. This is not something like this is like an actual data which is present available over the internet, and they lot of organizations do these research. INTA does that, WTR does that. So they come up with the filing data. So this is only about that how these filings have been increased and the analysis of Madrid protocol. Can I have the next slide? So this is like a graph analysis of Madrid applications, which countries are like filing more applications, how they are increased, how this has been increased. So this is also the more similar analysis of the data that from 90s to 2018, how this countries have been increasing using this Madrid protocol. They are becoming part of Madrid. So talk about the usage of data and how the Madrid have been growing since 2000 since 1990 till 2018. So that's all about Madrid, which I have been practicing, and which I think that is important for any individual or attorney or corporates to know about Madrid. If I talk about in Indian perspective, Madrid came in India in they got affected in 2013. Yeah, the perfect slide. So in July they started effectively using this Madrid protocol, and they provided the Indian Patent Office, the Trademark Office provided the particular platform for individuals to file these applications through India. Previously, it was started as hard copies that you have to send. Now it is complete online process, which will help, and they keep on making it more user friendly. So now, if someone wants to decide file an application from India, they can easily file through the Indian Trademark Registry, and they can enter into international applications. So that's all about how India is using Madrid, how an individual can take benefit out of it, what all things an individual, an attorney, or corporate have to keep in mind before they use this protocol, what could be benefit for them, what could be a challenge for them. So that's all from my side today. I hope everybody liked the session, and in case you have any questions, I'll be ready to answer that happily.
Thank you, sir, for the wonderful session on the Madrid protocols. And now our audience have few of questions, so we will be asking you one by one. First of question from Vishnu Prasad Sahu. What is a bilateral treaties and multilateral treaties? Sir, you are not audible. You are on mute.
Bilateral treaty is this is a treaty which is like, for example, India recognize. Let's take an example: U.S. and India. U.S. Recognize India as a. For example, I'm a lawyer in India. I did my bachelor's in law in India. Do they recognize in US my degree? So these are called bilateral treaties. So if my country is recognizing something, will the other countries also recognizing my recognition as in same value as I do it in India? So these are called bilateral treaties, but I think this is an out of syllabus question. This is not a part of Madrid. Paresh, can you put some light on it? Dr. Paresh, can you?
Yeah, exactly. You said, So this is what you said is the same, bilateral treaties. So here I can quote, history of this one. When these Paris Convention started and when these all, international IPR treaties came into focus. Because long time back, 200 years, 300 years back, it used to be bilateral treaties or multilateral treaties. So it was like in Europe, two, three countries were working together and they used to form a but there was not universal or you can say that worldwide any treaty was that. So that came into effect from Paris Convention where the 13 member joined and now around 160 50 members are there. So that's why you are saying is correctly that bilateral is between two countries, multilateral maybe more than two countries are involved in the treaty. And first of all, I would like to say thank you, Jitendra, for joining us. And I apologize from my side, because my electricity was down and it was coming up and down quite on and off for 5 6 times. So because of that's why I was off from this platform. But however, I was following you on this YouTube, and I have uh, follow your this one. So I would like to introduce Jitender now, because he is IPR attorney and he is having more than 15 years of experience, and he has a LLB degree, and he has also completed his IPR PG diploma from ICFA University, and he is having the business administrative PG diploma from IIM Ahmedabad and IIM Lucknow. He has worked, in the companies called CPA Global, and then in MetLife he is a IPR team lead uh, from last around 6 to 7 years. So he is having vast experience, and he is experienced in international trademark laws and international trademark attorneys. So he is having knowledge of IPR, means trademark law, all around the Europe, USA, India, China, etc. So I thank you, Jitender Kumar Sharma, for joining us and giving the wonderful lecture. And I also thank Vikram for organizing this one. So if we have more question, then Vikram can scroll down. If
Vikram, do you have
you can
more
see any
questions on
questions
it?
are there.
Sir, we have one question more from.
Yeah, tell me.
Is there will be a centralized and decentralized processor for applying trademark for European countries?
So for European, if you are filing through Madrid Protocol, they once you select the European countries, so they have an option that you pay a EU application and it will be applicable for all the EU participant countries. I already discussed about the CTM trademark in it, like the community trademark. This is especially for European countries, but I also talk about the benefits and advantages or disadvantages of CTM trademark over Madrid Protocol. So yes, there is a centralized process which is called CTM. If you file through Madrid Protocol, yes, you can select it a EU country, but same thing applied to, like, if it is rejected in one, it is rejected in all. So, but it will help you if you are going through a Madrid Protocol. It will definitely help you to selecting EU countries in a one check, and you get your application file in across the EU countries.
Yeah, thank you so much, sir,
I
for
think I've
sharing your.
answered their questions. Any more questions?
Yeah, no, sir. Any audience
Any
having any
question?
questions, they can drop in the comment box
So
so we can write to our speaker.
this one is on
Yeah. So
grounds.
I would like to thank all of you for participating in this event.
Shall we now going to bind up, sir? Paresh, sir?
Yeah. Just make a one announcement.
Sir, regarding.
Yeah, regarding that, we have completed 3 sessions of this week from 27th, 28th, and 29th. So all these three sessions are available on YouTube on OPF platform. And again, we are going to organize more IPR webinars on next week, and we have already scheduled for 4, 5, and 6th August. And we are going to have international speakers for this next week seminar. And so I invite all of the participants and all these viewers to join with us next week also. And you can fill out the feedback form so we can deliver your e-certificate also. So thank you all. And main purpose of this webinar is that we are going to start from the 1st August IPR course online. So all of you are welcome to take participant in this online course. where you will get the lot of materials related to international IPR treaties and conventions. And there you also have to give, two levels of examinations. And once you clear that one, then you will get the certificate also. And this is going to be recognized by one of the college, which is recognized by the NAC recognized college, is that Sri Ramakrishna Institute of Computer Educations and NCs from Gujarat. And we are also in contact with a couple of colleges and institutes who are becoming our academic partners. So they are also going to take part and then to be active in our this course also. So I welcome you all and thank you all for joining us. And thank you, special thanks, to Jitendra Sharma for giving an excellent talk today. And thank you, Vikram, for organizing this.
So you can access that link, and all the audience please note that directly the link is not accessible. You must have to take the screenshot for right now, and you have to type that link into the URL box of your supporting browser, and in that browser you can fill the webinar feedback. Thank you everyone for joining with us. We you soon in next week, 4th, 5th and 6th August, on the second week of this IPR course, second web series.